Thank you so much, Nilgiri Escapes, for allowing me to escape from Delhi to be in this beautiful land. I'm particularly happy to see a lot of children who've joined. So I'm just going to be very brief in terms of my intervention. Um, when I look at a concept like Biosphere Reserve, three things emerge very clearly: characteristic ecosystems, different biogeographic zones and regions, and human communities as their integral component. I don't know why it's still called Man and Biosphere Program. I think it should be called Human and Biosphere Program now. Uh, but if you look at the legal maze around Biosphere Reserve, I think Vijay Krishnan spent a little time on talking about the core, the buffer, the transition. But it's actually a mosaic of legal categories which legal people only understand sometimes, apart from their interpretation. Ordinarily, it would have been very easy if there was a biosphere reserve. We have signed a convention. We have Article 253 of the Constitution. We could have made a simple law that this is how biosphere reserve is going to be managed. But unfortunately, that's not the case. What is the case? With every administrative category. We started with tiger reserves in 1973. It got legal recognition only in 2006. We had elephant reserves from 1992. We are still struggling to call it any legal. We don't have a legal framework. There are decisions, but we are still out there. Then we have the biosphere reserves. Again, no formal legal framework. And then you have the concept of special ESAs or ESZs. And now, with some clarity that the Supreme Court has given as early as 24th April 2023, where they talk about what exactly you can do in ESAs or ESZs, which surround protected areas only. So there are two kinds of ESZs as well. And then we have the traditional 1865 model of reserve forests, protected forests, village forests under various forest legislations. Of course, you have the Forest Conservation Act. And then you have the national parks, the sanctuaries. Then 2003, we have the conservation reserve, the community reserve. Then you have the concept of biodiversity heritage site under the Biodiversity Act. You have new categorizations which are now legal, which is tiger reserves, where you have critical tiger habitat versus the buffer. Then, of course, you have the Forest Rights Act, where you have the community forest resource concept, the habitat of the PVTGs or the particularly vulnerable tribal groups, and then you have the critical wildlife habitat also as a concept. Now, all of this that I just mentioned is also part of the Nilgiri Biosphere Reserve. Now, you can figure out that each of those categorizations actually mean different things in law, and therefore its implications in anything that you do with each of those categorizations. So that's the first challenge. Now, we again have a very beautiful country where we've always drafted laws first and the policies later, especially when it comes to forest legislations, which I, as a student of law, always found it very interesting because, or rather strange. We have the first Act of 1865, which is the Forest Act, 1878, and then the first policy in 1894. Then we have the 1927 law, we have a 1952 policy. Then we have the 1927 law, and we have 1988 policy. And since 2000, we've been trying to have a new forest policy, but we are still not there. The point I'm making is it's time to realign the policy with the law. Policy first, and then the legal instrument to implement that policy. I don't know, for some strange reason, or probably this is how the British thought, we always had the act first and the policy later. We still don't. And then we have, of course, the National Environmental Policy, which is a broad base, broad brush of what things need to happen on the ground in 2004. We still don't have a national wildlife policy. We still don't have a national climate policy. We still don't have a landscape management policy, although we've been talking about it since eons. BJ just said that we are thinking about it since 1926. So that's the kind of policy framework we have. The complication gets a little more tricky when we come to the management regime that we have. If you look at the management regime, I'm sure most of you are familiar with working plans and working schemes, the Bible of the Forest Department, started from 1865 onwards. You have the management plans under the National Parks and Sanctuaries, which is under the Wildlife Act. Again, it's still not a legal document. You have the conservation reserve planning process. You have the community reserve planning process. Again, we don't have those in our protected areas network. Elephant corridors and elephant reserves, I'm not going to mention because that's a very contested topic in this region. You have also the concept of National Biodiversity Strategy and Action Plan. You have the State Biodiversity Strategy and Action Plan. But where are they in the public domain? I don't think many of us know that. Then, of course, you have the conservation plan concept under the Forest Rights Act. You have the micro plan concept under the JFM, which is the Joint Forest Management, Community Forest Management, Participatory Forest Management, different nomenclature around the country. We still don't know how they are made. Never made by the communities is what I find when I interact. Then you have the concepts of zonal master plan, sub-zonal master plans under ecologically sensitive areas. And then, of course, you have the core, buffer, and transition zones in the Biosphere Reserve. Look at the kind of management tools we have not interacting with each other at all. And this is the problem, in my understanding. From planning, we go to strategies. You have the National Environment and Conservation Strategy, you have the Wildlife Conservation Strategy, you have the National Biodiversity Strategy, and of course, you have the NAPCC, which is the National Action Plan on Climate Change, with 4 relevant missions as far as biosphere reserves are concerned. Both the missions on sustainable habitat, on water mission, on the mission of Green India, and of course, the mission of sustainable agriculture. I think what we've done in terms of the policy and the law is created such a complicated mosaic that's very difficult even for a student of law who's been practicing for 32 years to even understand what it really means on the ground. So that's the challenge, huge challenge. I'm not even talking about the institutions that we have created. We have created statutory institutions. Within the statutory, we have regulatory, recommendatory, advisory, we have court initiated, we have administrative institutions, we have participatory institutions, we have customary institutions, we have international fund initiated institutions. And I'll give you a small example. When I was working in Andhra Pradesh in the Forest Law Reforms Project, I found there was a World Bank JFM, there was a NABARD JFM, and there was a Forest Department JFM. So that's the kind of institutions we are building, unfortunately. So, how do we really address the threats that we have? I mean, the threats are known. I'm sure it was discussed in the last 2 days. But the challenge, I mean, whether it's infrastructure, whether it's forest based industries, whether it's urban expansion, whether it's agriculture expansion, whether it's unsustainable tourism, poaching, forest fires, monoculture plantations, the threats are galore. But how are we addressing it with that kind of a complicated legal maze? I think that's the challenge. How do we integrate the strength of those legislations and how do you really marry it to the development paradigm that we have is the real challenge. How do you connect the Wildlife Protection Act, the Biodiversity Act, the Environment Protection Act, the Forest Conservation Act, the Forest Rights Act? How do you really connect the two with infrastructure development laws, the Town and Country Planning Acts? I think that's a real challenge. And I think it's a huge opportunity for lawmakers or law students or advocates to really disentangle this complication and make it simple. We love especially lawyers, we love making it complicated. So I think this is the challenge. And when you talk of NBR, the Nilgiri Biosphere Reserve, we have a very peculiar context of 3 states. We have Kerala, we have Tamil Nadu, and we have Karnataka. 3 states, 3 perspectives, and don't forget the 3 different political regimes. The local laws add to that maze. Tamil Nadu has a Forest Act of 1882. We have a TNPPF of 1949. We have the Karnataka Forest Act of 63. We have very unique classifications like district forest in Karnataka. Then we have the Kerala Forest Act, which I'm sure the Honorable Judge knows more about it. Right from 61 onwards to the 71 Private Forest Act to the Ecologically Fragile Lands Act of 2003. So, where is the coordinating platform for all these mosaic of legislations which plays on the ground? I think that is, to my mind, a huge challenge. The Gadgil panel or the Kasturi Rangan and all these other versions of the Gadgil report talks about a Western Ghats Ecology Authority. Is that the authority that can take care of this complex mosaic? The problem is that is under the Environment Protection Act. So that is completely governed by a different legislation, which has got nothing to do with the forest legislation. So how do you really marry institutions like the Western Ghat Ecology Authority to look into these implications? So what's the way forward? I think for an effective landscape management that we're talking about, I think we need really huge reformations. We need all these laws to get to a simple framework where we actually map out this entire Nilgiri Biosphere Reserve or any of the 18 biosphere reserves that we have into a framework where the modern challenges are addressed. I don't think any legislation talks about climate change challenges or forests. How can you use that as an adaptation or a mitigation tool? How do you look at the CAMPA mechanism? For those of you who are familiar, the Compensatory Afforestation Management and Planning Authority, we are using actually, most of us know that pristine forests are being diverted, right? It's blood money that we have collected, about 80,000 crores, I'm told. How are we using that in the landscape? Are we really using it well? How do we balance the forest rights under the FRA regime to forest conservation? How do you ensure the rights are with responsibilities, and how do you ensure that conservation is with a human touch or a community touch? I think these are really the real challenges, because extremes have never worked. I come from a state called Jharkhand, and extremes have always produced only extremists. And I've personally seen the left wing extremism that which is so serious in the entire red corridor that we could talk about, we know about. So the last thought that I have is to look at this entire regime of forest management, on biodiversity management, and also look at it from when you look at it in the context of biosphere reserve, kindly look at it from a community intellectual property concept also. I don't know how many of you are familiar, but community intellectual property is now a right under the Forest Rights Act. No, that could be one of the fulcrum of looking into community knowledge and conservation in a big way. And last but not the least, I think educating and orienting key stakeholders. And when I say key stakeholders, I mean administrators, foresters, with all respect, judges, and lawyers on this aspect is very, very essential. I was so pleased to hear the Honorable Judge talking about him going to the field and understanding the context. Because for many of us sitting in Delhi, etc., when you talk about Banni, which is in Kutch, by the way, or Bhitarkanika or an Aribada in Orissa, or Ladakh or Changthang, it's a word. But for a lot of people who actually go and see, it's a film. It's a context that you relate to. And I think a lot of environmental policy making or legislation that we are trying to draft must be based on those landscapes, which we understand by really seeing it and experiencing the problems with the community interaction. So I just want to stop there, and I hope uh, that this kind of a conclave really leads the way in untangling this maze that I just described. And maybe the Nilgiri Biosphere Reserve will show the way to the rest of the 17 in telling India how biosphere reserves can be managed. Thank you so much for your time.